Ethan and Hila Klein are being sued by their former housekeeper, and people are saying that this is proof that they mistreat their employees. What's crack? It's VangelinaSkov, and welcome to another episode of I Don't Know What a Super Bowl is. And at this point, I'm too scared to ask. Now, today, I want to talk to you about Ethan and Hila Klein and this whole lawsuit. I do have right here the entire lawsuit. I have gone and I've highlighted the relevant bits so that we don't have to read 500 billion trillion pages of lawsuit and legal jargon. So we're going to read through just the main points. And I also have here Ethan Klein's response. So to start off with, we have the complaints that are being made by his and Hila's former housekeeper, which is violation of California Family Rights Act, disability discrimination in violation of FEHA, retaliation in violation of FEHA, failure to provide reasonable accommodation, failure to engage in interactive process, failure to take reasonable steps to prevent discrimination, retaliation in violation of California paid sick leave law, wrongful termination in violation of public policy, failure to provide a meal and rest period, failure to pay overtime, failure to pay failure to pay state local minimum wage. No, still did it wrong. Failure to pay state and local minimum wage, failure to pay all wages due, failure to furnish wage statements, waiting time penalties, failure to provide personnel records, and unfair competition in violation of this code. That was a lot. You know, I really thought after everything ended with the Illuminati stuff that the next time that I had to read legal documents wasn't going to be until there was a hearing about the dissociated Sergio Costa stuff. But apparently not. Here we are. So allow me to have a sip of coffee before we go into details of what this all actually means. So this starts off just explaining the facts of the matter. If you've ever seen legal documents, it has to explain who everyone is, who the company is, because this is, as we saw, it is against Hila Klein, Ethan Klein, and Teddy Fresh Inc., as well as some unnamed defendants. But since they're unnamed, we're going to focus on Teddy Fresh, Ethan, and Hila. So this just explains who they are. And there's some interesting stuff here, which is on information and belief, the Kleins and TFI, which is Teddy Fresh Inc., are and were engaged in one or more of the following: commingled funds and other assets, failed to segregate the funds of the separate entities, engaged in the unauthorized diversion of corporate funds or assets to other than corporate uses, treated assets of the corporations as though they were individual assets, such as by paying personal debts with corporate funds or utilizing corporate funds to purchase assets for individual shareholders with no discernible benefit to the other shareholders. And it goes on like this. So basically saying that they used company funds for things that weren't company related, for their own benefit, to buy things to pay their own personal debt, when company funds should be used for company stuff. Now, not 100% sure why this was added here, because it's not entirely relevant to the damages that are being alleged here, but I digress. We'll move on. And then we get a bit of background on the housekeeper herself. So plaintiff, who is the housekeeper, served as the full-time personal housekeeper to the Kleins, beginning on approximately December 16th, 2020. She was well regarded during her time with them and fulfilled her job without issue, including cleaning the house, doing laundry, making meals, regularly performing errands, and grocery shopping. During her employment, plaintiff suffered from a hernia of which the Kleins were aware. On June 18th of 2024, plaintiff learned that she would need surgery for her hernia. The very next day, on June 19th, at 10 a.m., she notified Mrs. Klein that she would be needing time off for hernia surgery on July 19th. Additionally, she told Mrs. Klein that her doctor expected her to need a month to recover, but that if she felt better sooner, she would return earlier. On June 20th, 2024, plaintiff placed a call to Karen in TFI's Human Resources Department as she was having a problem with her time card login. She notified Karen by voicemail on that date that she would be going out for surgery on July 19th and that her doctor expected she would need a month to recuperate. Shortly thereafter, on June 20th, only 2 days after plaintiff notified her employer that she would need time off for the hernia surgery, Carrie Bish, which is an excellent name, EDP of Finance, called plaintiff to notify her that her employment was being terminated and that she did not need to return to the house. Days later, as Ms. Bish attempted to have plaintiff sign a release, which plaintiff declined to sign, plaintiff pressed for a reason for her termination. Ms. Bish responded that her employer was going in a different direction and referenced a problem that she had with the Klein's nanny. This reason was pretextual. Defendants terminated plaintiff because she requested time off for her hernia surgery. So I know I just read all that, but just to sum it down, she had a hernia, she was going to need to have surgery, would need time off for that, and would need a month off to recover. She notified them of this, and then 2 days later she was fired. And she was told the reason that she was fired was because of other issues, because of an issue that she had with the nanny, even though it was 2 days after she had requested this time off. It does look really sus. One thing I will never understand is how in America you can just fire somebody on the spot and it's like, okay, you're done working for me now. You have to give a notice. I don't know. Here you need to give a notice. It's so bizarre to me. And also the fact that people can just quit as well on the spot. I was like, no, no, no. You have to give a notice. You can't just leave. So then we get to the first cause of action, which is violation of the California Family Rights Act. Defendants in each of them violated the California Family Rights Act by refusing to provide plaintiff the medical leave to which she was entitled, and by retaliating against her for exercising her right to medical leave for her serious health condition. In engaging in the aforementioned conduct, defendants, and each of them, aided, abetted, incited, compelled, and or coerced unlawful employment practices in violation of the announced policy of this state against such practices. So basically saying she was entitled to leave, they denied her this, and they retaliated against her. As a direct and proximate result of the conduct of defendants and their agents, plaintiff has suffered and continues to suffer general damages in the amount according to proof with interest thereon. Plaintiff has suffered and continues to suffer economic and or special damages in an amount according to proof with interest thereon. Plaintiff has suffered emotional distress including, but not limited to, humiliation, embarrassment, and mental anguish in an amount according to proof. Just to tell you now, for each of these cause of actions, it's going to say she has had damages, economic, emotional, all of that, because they need to prove that there's actually damage done in order for a lawsuit to be necessary at all. Because if stuff happened but it didn't cause any issue to her, then it's unnecessary. So it says that for every single one of these, but I'm not going to read that every time. So just know that it says that, but it's going to get really repetitive really fast if I keep reading that every single time. Then we have the second cause of action, which is disability discrimination in violation of FEHA. Pursuant to government code whatever, employees may not terminate employees or discriminate against employees in the term, conditions, or privileges of employment because of an actual or perceived disability. Plaintiff suffered and or was regarded as suffering from a disability, a hernia, and required and requested reasonable accommodation for it, namely a medical leave for surgery and recovery. At all relevant times, defendants and each of them were aware of plaintiff's disability and or regarded plaintiff as suffering from disability. Defendants discriminated against plaintiff because of her disability, including by terminating her because of her disability. Moving on to the third action, this is retaliation. So it's saying that plaintiff requested defendants to reasonably accommodate her disability, including by giving her time off to have surgery and recover. In retaliation for her request of reasonable accommodation, defendants and each of them subjected her to adverse employment actions, including, but not limited to, terminating her employment. So you'll see here that it's saying that this was discrimination and it's also retaliation because they retaliated by allegedly terminating her because she asked for time off. Fourth cause of action is failure to reasonably accommodate disability. Pursuant to whatever government code this is, it is unlawful for an employer to fail to make reasonable accommodation for the known physical or mental disability and or perceived physical or mental disability of an employee. Plaintiff suffered and or was regarded as suffering from a disability and required and requested reasonable accommodation for her disability. Defendants and each of them were fully aware and had knowledge of plaintiff's disability and or perceived disability, and this is, as was mentioned earlier, that she had notified them as soon as she'd known, and also of plaintiff's request for reasonable accommodation, including time off. Notwithstanding this knowledge, defendants failed to reasonably accommodate plaintiff, including but not limited to failing to accommodate her need for time off to have surgery and recover, choosing to terminate her rather than reasonably accommodate her. Then we have the fifth cause of action, which is failure to engage in interactive process. I'm not going to read that one because it just kind of it's a bit of waffle, okay? You can read it, it's on screen. Sixth cause of action is failure to take all reasonable steps to prevent or correct discrimination. So this government code says that employers have an obligation to take all reasonable steps necessary to prevent discrimination from occurring by their conduct, including but not limited to training their managers adequately in employee rights to reasonable accommodation and medical leave, and failing to engage in an interactive process with plaintiff to determine a reasonable accommodation, and terminating plaintiff because of her disability and request for accommodation and protective medical leave. Defendants and each of them and or their agents, employers, no, it does say employees, failed to take all reasonable steps to prevent discrimination from occurring. So basically, they didn't do enough to stop the discrimination. This is a lot of things that are just kind of saying the same thing, but presumably she went with this complaint to a lawyer, and the lawyer said, well, here's all the different angles that we can take with it, and technically it looks like they violated these different codes based on what you're telling me. So we're just going to go with all the angles, because why not? Something will stick, maybe. Seventh cause of action is retaliation in violation of California paid sick leave law. By their actions, as set forth above, defendants violated Section 233 and 246.5 by retaliating against plaintiff for her attempted use of paid sick leave, including but not limited to by immediately terminating her when she requested a medical leave to have surgery and recover. Is it true that Americans have like a limited number of paid sick days? Is that true? Because if that's true, that's really weird. I heard this somewhere the other day and I couldn't believe it. I was like, what do you... Yeah, I think I heard it on a TikTok, so I don't believe that everything TikTok says is true, so you can confirm or deny in the comments, but if it is true that you're only allowed to be sick for a certain number of days, that's absolutely ridiculous. Like, you can't help if you're sick. It's so stupid. Anyway... Eighth cause of action is wrongful termination in violation of public policy. Now, I did highlight all of this, but it's kind of just reiterating what was said earlier, that she was wrongfully terminated, that they fired her because of her needing time off, and that was not okay. Basically, that's what it says. So I'm not going to read all that again. That's boiling it down to what it says, but it's on screen for you if you want to read that. The ninth case of action is a bit different, actually. This one is failure to pay meal and rest period compensation. So, the code and wage order provide that an employee is entitled to an uninterrupted off-duty meal period of not less than 30 minutes for every 5 hours work. It also requires the employer to pay the employee 1 hour at the employee's regular rate of compensation for each day that the employer does not provide at least one required meal period. The code and wage order provide that an employee is entitled to an uninterrupted off-duty rest period for not less than 10 minutes for every 4 hours worked, or a fraction thereof. The code and the wage order also require the employer to pay the employee 1 hour, blah, blah, blah. We read that above. Plaintiff's initial schedule was 8 a.m. to 4 p.m. schedule, which was later changed to a 7 a.m. to 3:30 p.m. schedule 5 days per week. During that time, plaintiff never took either an uninterrupted meal break nor an uninterrupted rest break because she had to remain at the house and because there was not an opportunity to do so, given back-to-back tasks and requests by the family. In addition, Teddy Fresh Inc. nonetheless docked plaintiff 30 minutes of pay each day that she worked, despite that plaintiff never had an uninterrupted 30-minute meal break, and despite that she never clocked, wow, imagine I could read, that she never clocked out for one. Therefore, plaintiff is owed 2.5 hours of pay on each day, or 12.5 hours each week that she worked for defendants. Oh my god! I swear to god I can read, lads. So basically this is saying that she didn't get a lunch break, that she was requested to do so many back-to-back tasks that she never got a chance to have a work break, a lunch break, but they docked her pay for a half an hour each day. Question one is, are you not supposed to be paid for your lunch break? Regardless, she didn't work one anyway, so why is she being docked? And even if she wasn't being docked, she is required to have a lunch break. You need to have a lunch break. That's the law. Plaintiff worked for defendants for approximately 3.5 years, 182 weeks, and she is therefore owed approximately 2,275 hours. Plaintiff's hourly rate at the time of her termination was $30 an hour. She is therefore owed approximately $68,250 in reimbursed time and meal rest break penalties. Then the 10th cause of action is failure to pay overtime compensation. So it says that the code and wage order provide that a work day consists of 8 hours and a work week consists of 40 hours. And an employer must compensate an employee who works overtime hours with either 1.5 times or double the employee's regular rate of compensation. Defendants employed plaintiff for shifts in excess of 8 hours per day, but failed to properly pay her at the overtime rate for all overtime. So this, they're saying, is not chill. Pay her for her overtime. The 11th cause of action is failure to pay state and local minimum wage. And what this is saying is that because she wasn't paid for her overtime, she was not getting the required minimum wage. The 12th cause of action is failure to pay earned wages, which is getting to the same thing, basically. And the 13th cause of action is for failure to furnish timely and accurate wage and hour statements. This one basically says that she was asked for timely and accurate wage and hour statements, so how much she worked and how much she was being paid, and that they failed to do this, and it did not actually reflect the hours that the plaintiff, the housekeeper, had worked. The 14th cause of action is waiting time penalties. Labour Code sections 201 and 203 require employers to pay employees all of their earned wages immediately upon discharge and or within 72 hours of resignation. And it's just saying that this did not happen. 15th cause of action is failure to provide personnel files. So it's saying in August of 2024, this former housekeeper asked for her personnel file and wage records. Though defendants produced some records, the production appeared incomplete, and over the course of the next several months and repeated requests for time records and signed documents, defendants have to date failed to timely and properly produce plaintiff's complete records, including time records. Plaintiff is entitled to the records requested, but she hasn't gotten them yet, it seems. And here is what she's asking for. So, compensatory damages, economic and non-economic damages, general and or non-economic damages, damages for emotional distress, for all compensation and wages that's owed to her, for all penalties and liquidated damages provided for in the California Labor Code, for all wages in lieu of rest and meal periods that were denied, as well as interest, that defendants be ordered to restore to the public all funds acquired by means of act or practice declared by this court to be unlawful or fraudulent or to constitute unfair competition, punitive damages, so punishment basically, injunctive and declaratory relief, reasonable attorney's fees, for cost of suit, for prejudgment interest, and for such other and further relief that the court may deem just and proper. What is happening to me today? This is the curse of Ethan Klein. I can't speak English. And she's also demanding a trial by jury, which I don't know how that will go down. So if this is all true, this is really, really bad. It's saying that they fired her because she asked for time off because she needed surgery for a hernia. Like, you can't really avoid that if you need the time off, can you? And, oh, God, they also, like, didn't give her time off for a lunch break. They didn't pay her for overtime. Like, it's looking really bad. Now, I have to say, this is all obviously alleged. It has not been proven in court, and it may come out in favor of Ethan and Hila. It may be that they haven't done anything wrong at all. But if it is true, it's really, really bad. And I do think it's suspicious that she worked for them for 3 years, and they're saying she had other issues that they were going to fire her for, but she worked with them for 3.5 years, and it was 2 days after she requested time off to recover from surgery that they fired her. It's just very suspicious. Now, I have Ethan's response, and yes, I did get it from the H3 Snark because that is where it was posted, and I missed his story when it was live, okay? But somebody posted this on Twitter, and he responded saying, "Our former housekeeper was fired for being horrifically rude to our boy's nanny, constantly calling her fat and asking when she gained all the weight. I gave her so many warnings hoping she would just stop, but she didn't. She was part of our family and we treated her like it. I tried everything to salvage the relationship, but her conduct was inexcusable. This is all documented with HR, which hopefully makes this an easy matter to settle. It feels extremely violating to know that someone that close to our family can turn around and do something like this. The part about her asking for time off for her hernia surgery and then being fired is 100% fabricated. Anyone that knows us or works for us knows that that is not something we would ever do. I care deeply for all of our employees and do everything in my power to do right by them. She tried to shake us down for a huge amount of money, which I immediately declined, knowing our innocence and refusing to ever concede to people like her." Now, if he's telling the truth, fine, because obviously, even if I don't like Ethan Klein and I don't like Hila Klein, there are bad actors in the world. He's saying that her asking for time off for the hernia surgery is fabricated. Now, I don't know if there's some kind of paper trail that she has to prove that she requested this time off, because she's saying it was on the phone, and I assume phone calls aren't recorded. So for this to be a proper lawsuit, I would assume she has some kind of paper trail, but if not, she's not going to be able to prove this, especially if Ethan is telling the truth, that HR have all the documents and a paper trail to say that the housekeeper was being rude to the boy's nanny and that they were trying to correct this behavior. And then he posted another story that said, "Also, it's worth mentioning this is extremely common when you employ a lot of people. Surprised it didn't happen sooner." I wouldn't say it's a good look to say, "Wow, I'm surprised I haven't been sued by one of my employees yet." Like, that doesn't make you look innocent. That kind of makes you look bad. That kind of makes you look like you're doing stuff wrong. I get the point that you're trying to make, but like, come on, dude. So until more information comes out about this, we can't be sure what's going on. Obviously, everything is alleged. I do find it sus that if there is proof that she requested time off for the hernia surgery, that they fired her 2 days later. And Ethan, being the capitalist that he is, it kind of wouldn't surprise me that he would be like, "Oh, well, she's going to be a liability. I'm going to have to pay her for like a month while she's not working and hire somebody else, even though I could simply clean my own house." But okay, sure. That's neither here nor there. Employ people. That's fine with me. Spread the wealth, whatever. But it wouldn't surprise me, but that is not saying that it's true. I'm just saying it wouldn't surprise me, okay? Don't sue me. You're already involved with your own lawsuits, all right? Now, there is also this clip that people have been bringing up from the podcast where they're talking about somebody with a chronic illness. I believe in this situation they're talking about Jake Doolittle. That's a whole drama I still know nothing about. I know, I need to look into that one. But just here's what he says.
Dude, imagine if you hired this guy because he was applying.
You'd never be able to get rid of him. He is an HR nightmare.
No, he wanted a job. That's why he.
You would never be able to get rid of him.
I've worked with people like this, and the thing is,
once you work with someone like this, you start realizing, oh, this is why there's such like strict HR interviewing process, like 20 layers.
Because you'll never shake that guy.
Not only that, like when you realize that, like not only are they not helpful, but they're like detrimental to everybody and the environment and everything around them. When you try to fire them, they will 1000% file a discrimination lawsuit.
It's California, so it's
make
tough.
anything up.
Yeah, to beat those. I think Jake could be in the other seat someday, possibly.
No shot. There's no
Co-host?
chance.
Co-host
He blows
potential?
and he sucks.
0% chance.
I
he'll
hear
ever
he
work
worked
here.
on SNL. That's a
Coveted
that's
job.
a big resume line.
Yeah.
You know?
New writer.
Wrote some of the greatest bits.
Dude, I wouldn't.
Now, I don't think this necessarily proves anything, and it is a little bit out of context, but it does show his attitude. I swear to God, Ethan Klein has cursed me. I can't speak. It does show his attitude towards stuff like this, like saying, well, the other guy said, hate your nightmare, but he's agreeing and saying, you know, somebody like this, they're absolutely going to file a discrimination thing if you try and fire them. So it is a bit of a weird attitude to take. Again, doesn't prove anything. But I wouldn't be surprised, okay? I wouldn't be surprised. Not saying him and Hila are wrong, but I wouldn't be surprised. What do you think, though? Do you think they're guilty as sin? Because I think you can say whatever you want in the comments, to be honest. Do you think they're innocent? Do you think they're guilty? Don't take what I just said as legal advice. I'm not a lawyer. Obviously, I can't even pronounce half the words that I was just reading. I wanted to say something to you guys as well, which is that this is the 3rd day in a row I'm uploading. Like, in a row. This has not happened since COVID. So please subscribe. Thanks. And like this video, because it makes me feel good. And also, just do it, because I asked. Thank you so much. Let me know your thoughts in the comments. Like, comment, share, follow me on social media. I'm VangelinaSkov everywhere. Check out the Patreon. Have an absolutely wonderful rest of your day. And I will see you in the next one. Bye.